This is Gabriel Custodiet of Watchman Privacy. I know why you're here. You're looking to escape the technocratic apparatuses that you see slowly enveloping you and restraining your freedom. For the fundamentals of privacy, you should start by visiting escapethetechnocracy.com to see my video tutorials, books, and other resources for getting off the surveillance grid. Watchman Privacy and Escape the Technocracy are leading the fight for privacy, and unlike just about any other show, we practice what we preach. Private payment options, no threat modeling, no statist or collectivist solutions, and no sponsors, ever. You know what that means? It means we can speak the unmitigated truth as we see it. Your support alone determines the future of this show. Go support you and me at escapethetechnocracy.com. I'm very pleased today to be joined by Mark Knapp. He is a firearms lawyer. I'll let him talk about where he's licensed and all the rest, but his website is firearmslawyer.net. And you can follow him on Twitter at Firearms Lawyer. And then he's also on Facebook. I'll have some links for people who would like to reach out to him, follow him. And I want to pick Mr. Knapp's brain about a few topics pertaining to guns, self-defense, things of this sort. And of course, the world that we live in is one where we have gun control, right? And I think it's important to contextualize things by saying that weapon control is really a recent phenomenon, right? A recent phenomenon in the last, let's say, 100 years with the illegal industrial complex and the cult of safety. I think it's useful to recognize that the current moment is a historical aberration. People throughout history have had access to a weapon to defend themselves, right? And to serve in a militia or something like this. And I do think that people will look back at this era in terms of sovereign weapon ownership and the crackdown on it as the epitome of barbarism. I think that's how this era will be remembered. John Jay says that government that wants away citizens' right to bear arms is unworthy of trust. And another good one comes from George Mason, who says that to disarm the people is the most effectual way to enslave them. So, Mr. Knapp, welcome to the show. How are you doing? Maybe you could give people a little bit about your background.
Oh, I'm doing really great now. I've been practicing law for 35 years in Washington State, and I went to school at law school was Gonzaga School of Law in Spokane, Washington. So I graduated back in 1989, and then along the way, I decided I want to get really more versed in firearms, and I was working for the provider firm for Legal Shield, formerly known as Prepaid Legal. A lot of people were calling about questions with firearms, and I decided that would be a good niche to be in. And since then, I've become a real activist, and I took a lot of classes and got a concealed pistol license. I even started a armed self-defense group over in Federal, Washington. That's in between Seattle and Tacoma. It's the Armed Defense Training Association. I got into competitive shooting, and it's really been a lot of fun and very interesting and educational.
Absolutely. So you have a lot of experience here, and maybe for people who are listening and they might want to reach out to you, who are you able to help? Is it just people in Washington?
I'm only admitted to the Washington State Bar, which means I can be admitted to the two district courts. We have Eastern Washington, and then we have the United States District Court for Western Washington. The Cascade Mountains are more or less the dividing line. And I'm also admitted to the Ninth Circuit. Ironically, or paradoxically enough, I can appear down in California in the Ninth Circuit, but I'm only admitted to the federal courts in Washington at the trial court level, which would be the two district courts.
Understood. And I guess we should mention here now that not legal advice in this show by any means. And even though Mr. Knapp is a lawyer, he's certainly not your lawyer. We're just giving information. This is just entertainment. And the good thing though is that there are some similarities of gun laws across the country, and so it is useful to pick somebody's brain who has this expertise, even if his area is Washington. It's certainly some of these concepts can be thought of more broadly. And I wanted to start, Mr. Knapp, just get your thoughts, especially having been a firearms lawyer for as long as you have, kind of the big picture of what people are up against in the United States, people who own guns. Maybe they're traveling with guns. Maybe they want to use guns for, they have one for self-defense. How bad have things become in the U.S. illegally? What do you consider the landscape of, gun laws in the U.S.?
Well, when you look at the nation as a whole, things have been moving in a very positive direction, all the way back to the 1990s. But at the state level, more than half the states now have what they call constitutional carry. in the state of Idaho, just for example, we don't need any concealed pistol license. When I started working with firearms issues, there were only a few states, I think Alaska and Vermont, that did not require a concealed pistol license. But a real case in point to answer your question is Washington State itself. 20 years ago, Washington State was one of the best states when it came to firearms. And just in the last several years, there have been bans on so-called high-capacity magazines, bans on AR rifles. They made it so that any transfer, no matter how temporary, just even borrowing a gun, you're supposed to go get a background check through an FFL dealer. It's just one thing after another. Put so many restrictions on people that I call Washington State occupied territory. Even though I only practice law in Washington State, I live in free America. I live in North Idaho, and then I'm just about a 1 hour drive from Spokane. Spokane maybe not so bad, but almost as bad as California. Let's put it that way. And that's pretty bad.
Right. You're kind of crossing the Iron Curtain when you go to work. So having maybe defended people or certainly been aware of some of the people who get in trouble for gun-related things, could you reel off a couple examples of some just absurd convictions of people or situations people have been in who are simply trying to own a gun, in a way that would have been aligned with the founding fathers? Any kind of crazy situations that you've either been part of or that you're aware of?
Well, one example is I had a case involving, actually I've had two cases now involving red flag laws. Washington, they call those ERPOs for short. It's an acronym, Extreme Risk Protection Order, also known as red flag laws. So this client of mine, he really was talking some pretty strong language to the city council because he didn't like the fact that I won't name the city, but they were letting all these homeless people in, and he was afraid it was going to get to be like Seattle, where they had the Antifa take over Capitol Hill over there in Seattle. And he had some bad language and some things that he said to the city council, but he didn't threaten anybody. And the next thing, the police went and they basically took away his gun rights for a year. We got him a psychological evaluation, and then after a year, his rights were restored. But with these red flag laws, you want to be very careful what you say because you don't have to threaten anybody. All you have to do is have the police or a family member, or even could just be one of these Antifa people that just wants to punish you for being a conservative, and they could make a complaint and say, oh, he's been buying a lot of guns, or, he's been acting kind of strangely. It'll be totally up to a judge, and there's a lot of leeway. It can be very arbitrary and capricious sometimes how some of these judges rule. It depends on their worldview, but they have a lot of latitude, and it's very difficult to appeal a protection order of any kind.
I'm pretty sure that you work with self-defense scenarios as well. And this is one of those things which, it seems to me to be just a very basic moral principle that one has the right to defend oneself. But of course, these situations can go very wrongly. So I wonder if you could just spell out for people. Most people have never and will never be in a situation where they shot somebody who was trying to attack them. I'm just curious, for the people out there who want to understand what the process is. Okay, so somebody's in their house, there's all kinds of variables, but somebody's in their house, they defend themselves. What exactly is the process from that point on, from the legal perspective? How does it play out? I wonder if you could just give an idea for people who have no clue how this will play out.
I was doing a lot of classes for a while, both with NRA protection in the home and outside the home. I'm not certified to put on the whole class, but they have to have an attorney in there for 1 or 2 hours. So I had a friend that had me do several of those classes, and then I was doing some classes of my own. And one of the questions that inevitably comes up is, well, if somebody's in my home, can I shoot them? My answer to that is that's really the wrong question to be asking. The rule in the home, it's not a lot different than the rule outside the home, which is you have to have a reasonable belief that that person is presenting an imminent threat of deadly force. So The example I always use is when I was a kid, we had a neighbor that was, he had dementia. He was a real old guy, and he'd wander into your house. He wasn't a threat to anybody. Everybody knew the guy had dementia. So, of course, you wouldn't shoot that guy. But, yeah, if he was in your house in the middle of the night, that might make a difference. But what the jury or the judge is going to look at is what did you reasonably believe, based on the circumstances that you were aware of at the time. Would a reasonable person in your same situation shoot that guy? And, if it were dark, it's quite possible that it might be reasonable. In the Bible, under the laws of Moses, they treated it differently if you shot somebody at night than if you shot somebody in the day. But back in those days, well, they didn't have guns, but they also didn't have electricity. So you could kill an intruder in your home at night because, without electricity, it would be difficult to know what kind of enemy you're dealing with. So the bottom line is you have to look at the circumstances, and I recommend that everybody take some classes that go into the legalities of self-defense, because the way you develop judgment is by talking about various scenarios. And, the more different scenarios you think through and discuss with people that are knowledgeable about it, the more you develop that insight, because my motto is think like a man or a woman of action and act like a man of thought. You got to be thinking all the time, but if you hesitate and spend too much time thinking, you may not get a chance to make a decision because you might be dead if you're talking about deadly force. So the more you think through different scenarios by reading about different scenarios and talking to people, well, that's what you do in a lot of these classes. Like Masad Ayub he's the preeminent dean of firearms instructors, and he teaches civilians. And there's a whole network of attorneys out there and expert witnesses that have all studied under Masad Ayub. So that's the kind of a class you want to take, is a class where you can really spend some time learning about these things, but not just in a textbook fashion, but even doing live simulations and drills and tactical, practical, and legal. You got to somehow bring it all together. The best way to do that is with a professional instructor.
It does depend what state you're in, how strong these self-defense laws are. Obviously, you're a lawyer primarily in Washington, but I wonder, Mr. Knapp, if you could, what are some of the variabilities from state to state in terms of self-defense? Like how much leeway is there depending what state that you're in?
Yeah, it would be the usual suspects. You have what they call the Devil's Triangle, which is New York and Massachusetts and New Jersey. It can be, well, I'm from Chicago originally. That's another place right there where any kind of self-defense is very risky. And then a lot of times it's going to depend on politics of that state and everything else. But one thing that kind of relates back to the previous question is, we've all heard about castle laws. Well, castle laws are primarily for states where there was some kind of a duty to retreat. And that was only a minority of states. And surprisingly enough, it was mostly, according to my understanding, the castle laws were mostly in southern states. And part of the reason is because of the history of dueling. There was this code of honor where the South still would have armed duels long after people in the North pretty much ceased from that kind of thing. And Thomas Sowell talks about this, and there's a really interesting scholarly book called Black Rednecks and White Liberals. It kind of gives the whole history of rednecks, and he tells about two best friends, some slight insult, and the next thing they're out there with Bowie knives right in the middle of the street, fighting it out with Bowie knives. This guy carves up his best friend, over just some really stupid insult. And a jury probably would not have even convicted at one time, in the South. So that was the reason for the duty to retreat, is to discourage people from. It's also the reason that they allowed open carry, but they didn't like concealed carry so much in some of those southern states, because somebody challenged somebody to a fight, and the next thing you know, like they'd take out a knife or a gun or something, anyway, Washington never needed a castle law because there was never any duty to retreat. anyway, that's a majority of the states have always said that there's no duty to retreat through case law or whatever, maybe even by statute. That's how it was under the common law. There's no duty to retreat, but then some states needed castle laws because they were at risk when they protected, people were at risk protecting their home if they couldn't prove that they, were without the ability to retreat.
And yeah, so when you're looking up the laws in your state, you want to see, is this a stand your ground state or an avoidance state where you have some kind of abstract obligation to retreat instead of, standing your ground and firing. And of course, it gets into some really gray area, as you know, Mr. Knapp. And the reason why self-defense is such maybe a tricky thing is because if you are am I right in understanding that there's no middle ground in this kind of defense, that if you cannot prove that you defended yourself, it's a reasonable self-defense, then, well, you shot somebody, you killed somebody. There's kind of no middle ground. Is that typically how it works?
Well, in Washington state, which there's a little variation from state to state, but Washington says the burden never shifts. The prosecution always has the burden to prove every element of the crime. So in a self-defense shooting case, the judge will make an initial determination as to whether the jury is going to get a jury instruction on self-defense. So it's not incumbent upon the defense to prove that it's self-defense. There just has to be enough there that the judge says, yeah, there are self-defense issues. So now the jury gets the instruction, and the prosecutor has to prove that it was not self-defense. So at least in Washington, the defendant never has to prove anything. And then if the jury acquits on the basis of self-defense, it's interesting that the attorney's fees, to some extent, it'll be determined what would be a reasonable reimbursement for attorney's fees. So the jury actually determines whether there are going to be attorney's fees paid to the defense. Kind of, puts a little bit of fear of God in the prosecution, where, at least for the most part, they're pretty good in Washington about not charging people where, the facts look pretty good for self-defense.
For listeners who are maybe international, obviously, this also greatly depends what country you're in. For example, Mr. Knapp, I think of a instance in France where there was a farmer who was who had 4 burglars get into his house, and so he shot at them. He was alone with his 3-year-old daughter at the time. He shot at them and he killed one of them, and he was indicted for murder. And Macron, the president of France, came out and said about this incident, he said, I am opposed to self-defense. I don't want a country where weapons proliferate and where we consider that it's up to the citizens to defend themselves. So if you live in a place like France, you're expected to stand there and get killed, is what you're expected to do. So keep that in mind.
Yeah, Britain's even worse, I think. Britain's really bad.
There's some bad places out there for sure. So what about this, Mr. Knapp? For somebody who is involved, they're trying to prepare themselves mentally for a situation where, they're a gun owner, they're prepared to defend themselves. What should they, you mentioned getting into the mindset, practicing it. What other things should they have set up? And how should they prepare for that very stressful situation where there's somebody who they have to, shoot, who's coming at them in their house? How should somebody prepare for that?
I think competitive shooting is really good. I read one of the books by Masad Ayub when I first started getting deep into this about 20 years ago. You don't function very well under stress. So the more you can learn how to function under stress, in a competitive shooting situation where you're moving around while you shoot, I call it shoot and move or action shooting. 3-gun or USPSA or IDPA, those are some of them. International Defensive Pistol Association, that's IDPA. It's not as stressful as having somebody shoot at you, but you're going to experience jams and things like that where your gun jams, even changing a magazine might be hard to do for the average person if they're getting shot at. So the more you can learn to move around and keep functioning. Another point being, if somebody is shooting at you, you don't want to just stand there and shoot back, that's how most people train. That's why we started this Armed Defense Training Association, which now has two chapters in the Seattle area. I don't know how many members there are anymore, but I was the founding president. At one time, I think there were over 100 members, to teach people to shoot on the move. That's one thing. You do not want to be standing still, but most people, when they go to the gun range, they're not even allowed to move around. Most gun ranges don't let you do that unless there's some special event. Get involved with something like the Armed Defense Training Association or USPSA. That's the United States Practical Shooting Association. All these things are really good experience.
I love that is your answer for how to prepare for the situation. Practice shooting in stressful situations. What about from a legal perspective, Mr. Knapp? What should people make sure that they have in place? How should they engage with the police when they call the police and the police arrive? How should they handle that moment?
First of all, I'm going to say have a holster. Even if you're using a pocket gun needs to be in a holster. But I've heard so many horror stories and even represented people that got in trouble because they didn't have their gun in a holster. There's I could probably think of 5 or 10 good reasons to make sure your gun's in a holster. But if the police show up, let's just say you're in a parking lot and somebody comes at you and they're getting closer and closer and you tell them, hey, back off. And maybe you go to low ready. That might be a good idea. You tell somebody to back off and they keep coming at you, you might consider going to low ready. You got a pretty good defense if you don't actually point a gun at them, even if it's their word against your word, especially if they're within 20 feet of you and they keep coming after you tell them to stop. They're asking you for money or something like that. But anyway, so now the police show up. If they tell you to drop the gun, just drop it. But the best thing to do, and this is why you want to have a holster, would be to, when you see the police arrive, put that gun back in the holster. That way you don't have to drop your brand new gun on the pavement. But of course you want to cooperate with the police, keep your hands where they can see them. And then when they start asking questions, most attorneys would say, you just remain silent, don't tell them anything. That's because most defense attorneys mostly represent criminals. What we learned from Massad Ayub, and most of the instructors out there will tell you the same thing, is just answer some very basic questions like, okay, my life was in danger. That's the first thing you want to say is, I was scared, my life was in danger. This guy was coming at me. I told him to stop. Looked like he's a threat. Of course, then the question comes up, well, did he present deadly force? Well, that's why it's better to go to low ready than to point a gun at somebody. It's kind of a gray area, but at least if you don't point the gun at them, you can't be accused of an assault. You could be accused of displaying a weapon with the intent to intimidate. Other than that, let's say you actually shoot the guy. He's got a knife. Even at 30 feet away, a guy can run at you and stab you. You could shoot him, and due to the reaction time, he could still kill you with that knife, especially, somebody high on drugs and they're coming at you like at 90 miles an hour. Now the police show up. It's like, yeah, I was being attacked. This guy had a knife. I told him to stop. He was coming at me 90 miles an hour, whatever. Now the police are going to start asking for the who, what, where, when, and why. Oh, by the way, you might also, officer, the gun's right over there. That's where the gun is. There were some witnesses. You might want to go talk to those people across the street. They might have seen the whole thing. Here's where the bullet holes are. Here's where you'll find some casings. But when they start asking the who, what, where, why, and how, officer, I think you can understand. I'm really under a lot of stress right now. I'll talk to you just as soon as I've had a chance to rest, get back, get with my family and get with an attorney. And then I'll be glad to talk to you with my attorney present. They'll understand that because that's exactly what the police guild tells the police when they're in an officer-involved shooting. They can't use it against you. The prosecutor can't go and tell a jury, oh, he exercised his Fifth Amendment rights, therefore that's evidence of guilt. It would be a mistrial if the prosecutor even brings that up. So exercise your right to remain silent, but be cooperative with the police officers and let them know that you're in danger, that there was an imminent threat to your life, because their criteria right there, it has to be immediate, in other words, imminent, not somewhere, down the road, and it has to be a deadly threat of force based on all of the circumstances.
Should you have a lawyer ready to call? How should somebody vet a lawyer? Should you be part of organizations that are designed to help people in self-defense situations? What are your thoughts on that?
Yeah, there's a whole bunch of companies that some are like insurance and some, let's see, one of them is the Armed Citizens Legal Defense Network. That's out of Washington, but it's nationwide. It's not insurance, it's more like a foundation. I've been involved with them. I think I'm still on their list of referrals, but maybe not. I think I was supposed to update it a while back. And then there's the United States Concealed Carry Association. I know I'm listed with them as an attorney that is, on call. But there's a number of them. The NRA has some insurance, but I would say definitely create a relationship with an attorney and get that attorney's name and number, in your Rolodex. You want an attorney that's got some experience with self-defense and, understands firearms related issues, of course.
And should this lawyer be in your county or state?
I think it would help to have the lawyer be local. Yeah. I've got a lot of clients that are out by Seattle because I still get referrals from Legal Shield, and a lot of my referrals are from Legal Shield. But I would say, yeah, definitely there's an advantage to having a lawyer that can show up and, talk to the police just in case they do want to arrest you. Maybe sometimes a lawyer can actually change the mind of, the police, especially if the lawyer already has a relationship with the prosecutors and the local police and that kind of thing. We've been able to do that before. There was like example, I had one case over in Pierce County, that's Tacoma, and it was due to be arraigned like almost the very next day. This guy, he was a supervisor for a big corporation. He had a Christmas party or a New Year's party, and just a couple of his employees showed up. He provided the whiskey, and they started doing some horseplay, and the horseplay got worse and worse till pretty soon this employee was choking him out. Well, he had a brand new AK that his mom gave him for Christmas. And if you can imagine that, what a great mom. She gave him an AK, so it got so bad that he finally loaded that thing and took it out because this guy kept choking him out. And the guy was so drunk, the opponent was so drunk and so out of control, he grabbed the AK and pulled it right into his groin, and my client had his finger on the trigger. Well, we got a complete statement from him, and I got a retired police officer to help me put together this statement, right? We submitted it to the prosecutor, and the prosecutor said, okay, I'm going to investigate this further. He canceled the arraignment, and then about 2 weeks later, he said, yeah, we decided not to file charges. So that was a big success story where we never even had to go to court.
Okay, that's definitely a good reason to look in your particular area. Here's an odd question, Mr. Knapp. So some people like to have a private gun purchase, or maybe they're in a place where they can use something like a ghost gunner or something like this. Not talking about the legality of those things, but if you defend yourself with a gun, is the gun itself and how it was created or acquired, does that play into anything in terms of the the incoming legal stuff?
Oh, that's an interesting question. I'm not quite sure how to answer that. Now, I mean, I think this is relevant to your question. Mossad Ayub talks a lot about different kinds of guns. And for one thing, you don't want to do a lot of modifications. For example, most of my guns, I'll do some kind of a little trigger job on them, but you don't want to go too far below factory specifications. I mean, like, for instance, I think a Glock has like a 5 or 6 pound trigger pull. Most people don't really like the Glock trigger very much. All kinds of aftermarket things you can buy to lighten the trigger, but I wouldn't go a lot below 3 or 4 pounds. I mean, you could make the trigger a little lighter, but probably better to, just kind of smooth it out a little bit. And
so, for example, people have been seeing these videos of Glock switches. Now, as far as I understand, these are widely illegal. But if somebody defended themselves and they had a Glock switch that makes the Glock fully automatic, could that completely change their position of self-defense or get them into additional trouble, for example?
Yeah, I believe it would. It would because, well, first of all, to the best of my knowledge, they are illegal, right? Isn't a Glock switch a changes the Glock to a full automatic or something like that?
Correct. Yeah.
Just want to make sure, yeah, because I've been reading a lot about that. Very controversial. Yeah, absolutely. It's like Mossad Ayub even cautions against having like snake guns, he calls them, like the Colt Python, and they have a whole series of guns. I mean, those are great guns. I'd love to have one. A lot of them are collector's items. I understand they started making some of them again, but maybe that wouldn't be the best gun for a carry gun. Because the jury hears, oh, he had a Cobra or a Python. It already kind of prejudices the jury, just to know that, Mossad Ayub, he tells people, don't wear shirts with stupid slogans on them, anything that's going to prejudice the jury. If you're a concealed carry person, it's better just to kind of be that gray man, just kind of fit in. Don't put a bunch of fancy stuff on your carry gun or anything like that that's going to make a jury prejudiced against you, because ultimately the jury's not going to know a lot about guns, and they're going to get an idea of who you are, based on whatever information the prosecutor has, and he's going to try to prejudice the jury just as much as the judge will let him or her create prejudice.
What about this? You mentioned that it's important not to even point a gun at somebody. Let's say that's your crime. You pointed a gun at somebody. You didn't pull the trigger, but you pointed a gun at somebody, and they decide that it was not warranted. How much trouble can you get at for just pointing a gun at somebody?
Well, the statute in Washington, which is RCW 9.41270, I believe. Anyway, it's in the 9.41 series. It says that there's an exception to the rule if the other party, the adversary, whatever you want to call him, if he's engaged in an unlawful use of force. So, interestingly enough, I don't know how much attention a police officer would pay to this. It doesn't, the key word that's not in there, it doesn't say that he has to be presenting deadly force. It just says unlawful force. So if somebody were coming at you and you had reason to believe they were going to lay hands on you, but that individual does not have any apparent deadly force available, knife, gun, baseball bat, whatever, screwdriver, those would all be deadly force. Theoretically, you're not supposed to present deadly force against that person. You're just supposed to, defend yourself with martial arts or, whatever training you have, but you're not supposed to use deadly force. But that's the reason, by going already, you're displaying the weapon, and therefore that exception kicks in, because, that person is coming at you after you told them to stop, and all subject to interpretation. But once you point that gun, you have to be able to justify pointing the gun with a threat of deadly force. Now, if there's two of them, that right there is a disparity of force, which even if they don't have a weapon, the fact that there's two assailants justifies the use of deadly force right there. So at that point, you could point the gun at them, and if they don't stop, then you shoot them. But, that kind of assumes they're far enough away that you got time to make all these assessments. The trouble is, once you let them get inside your perimeter, which normally speaking is 20 feet or something like that in a parking lot, if somebody's 20 feet away from you, showing some indication of closing the gap, it becomes, a very tricky situation from a legal standpoint.
It's entirely possible, under the right circumstances, that just pointing a gun at somebody, you could go to prison for, say, years. That's feasible?
Yeah, for several years, I would say. Absolutely.
Now, what about Mr. Knapp? You mentioned different weapon types. Something like a taser or a stun gun that's not an actual gun. Is this going to be treated similarly as a gun, or does that, how should we evaluate that in terms of the risk of defending ourselves and being unfairly convicted?
I think there's a case going through the courts right now about that. Maybe it's in New York State. I'm not sure, but I know, just to put in a plug for the Second Amendment Foundation, they're right out of Bellevue, Washington, which is a fairly big city right across the lake from Seattle. And Second Amendment Foundation, a lot of these cases that the media report as being NRA, a lot of them are headed up by the Second Amendment Foundation, which is a lot smaller than the NRA, but they take on more than their fair share of cases very effectively too. So, well, yeah, because you're not dealing with deadly force. So I think all states make a distinction between assault with a deadly weapon and other varieties of assault. A stun gun, I wouldn't feel comfortable with a stun gun just because it might not work. I mean, it's not going to work as well as a gun would.
Sure.
And then even though it does kind of pose less of a legal risk, it can still get you in trouble. So personally, I think the laws dealing with firearms are a lot more clear-cut than something to do with a stun gun. Honestly, I haven't really dealt much with stun guns, so I couldn't say, but I think they should be protected by the Second Amendment, just like a firearm is protected.
What about the people kind of getting their mind, their finances, their legal status prepared in case they do have to defend themselves? What is the cost of a self-defense trial? Is this a huge sum of money just to go through the process of exonerating yourself? Or
oh yeah, it's going to be like easily $50,000 or $100,000. You normally want to have an expert witness. We had one case recently in Bellingham, Washington, not too far from the Canadian border up there, where two guys that were really drunk followed our client right to his front door, and they harassed him the whole time. Then they claimed, they just wanted to ask him some questions. They kept saying, we just want to ask you questions. But meanwhile, they were getting closer and closer to him. So now he gets to his front door. He'd already taken his gun out. He did not point it at them, but he had his gun out. They continued to get closer and closer. One of the guys, the guy that got shot 3 times, he was holding his hands up in the air saying, we just want to ask you questions. But they used some pretty provocative language. They were saying things like, you're just a pussy and all this kind of thing. Anyway, the bottom line is the client shot him once, and he thought he missed because the adversary was so drunk, he just kept getting closer. Shot him again, both times in the leg. Apparently the adversary still didn't know he was shot. The so-called victim. I'm calling him the adversary. He wasn't really a victim at all. I mean, our client shot this adversary 3 times. So it was a tough case. We decided to go just with a judge and not with a jury, which I think was a good move because Bellingham is a college town. And from what I understand, we probably would have gotten a jury that might not have been so favorable towards firearms. But maybe even more importantly is what we argued to the judge is that our client, he wasn't obligated to get into a wrestling match with 2 different guys, especially he had a reasonable belief that they knew he had a gun. They claimed they didn't even know he had a gun, but they were so drunk that the one guy didn't even know when he'd been shot 3 times. You think about it, if you've got a gun on you and you get into a wrestling match, at that point, the stakes are really high. Somebody's probably going to get hurt really bad. It's going to end up being a fight over a gun, which I don't know about you, but I don't think anybody would want to be in a fight with somebody, especially when there's 2 of them and you've got a gun on you. So the judge agreed with us and he acquitted that guy. So that's something you want to think through real carefully, is to make up your mind you're not going to let anybody take a gun away from you. I mean, I hope that answers the question. It might be a little bit, I hope it's close to answering your question.
Mr. Knapp, you get pulled over by the police. You have a gun that you are transporting in your vehicle. What is the proper way to deal with that situation and think about that scenario?
Oh, yeah, that's another question that comes up all the time. My belief is that you should always have that gun on your person, but not, I'm talking about Washington State, of course, but the law doesn't say that a loaded gun has to be on your person. A lot of police officers believe that, though. I understand many law enforcement officers in Washington State believe that your concealed pistol license is only good if the weapon is on your person. And by the way, in Washington, a concealed pistol license is only good for a pistol. The variation, like, for example, in Idaho, according to my understanding, because, of course, I'm not giving legal advice right now, but in Idaho, you can have a loaded long gun in your vehicle. You can have a shotgun, rifle. You don't even need a concealed pistol license. in Idaho, but in Washington State, if you have a round in the chamber, or even if there's not a round in the chamber, a lot of my clients have inadvertently thought they unloaded the gun, and then they get stopped, and the officer sees these guns. Oh, you mind if I take a look at your guns? I see you have some guns. Do you mind if I take a look at it? The answer should always be no. Don't try to be nice, because the police officer goes and looks at the guns, and then he finds out there's a round in the chamber. Or in the alternative, a lot of people think, oh, I'll put the magazine in the mag well, and I won't chamber round, and therefore it'll be legal. I'm talking about somebody that doesn't have a concealed pistol license. The next thing, they're in court, and now I'm having to try to get them some kind of a deal, because technically in Washington, the gun is loaded if there's a loaded magazine in the mag well. So the point being is, without a concealed pistol license in many states like Washington, you cannot have any loaded gun in your vehicle. And in Washington, you can't, if you're out hunting, you can't even lean a rifle. If you lean a shotgun or rifle just against, say you have it on the tailgate of your pickup truck, or you lean it up against the truck, they'll even cite you for that. The game wardens are out there looking for, a loaded rifle that's even leaning against your vehicle. And it doesn't matter that you have a concealed pistol license, because that's only good for pistols. So the bottom line is, have your concealed pistol license, keep the gun on your person, even though it's legal to have it in your glove compartment or under your seat. I mean, think about it. If you're in an automobile accident, or you got kids in the car, or whatever, you don't want a loaded gun floating around inside your car. From a purely self-defense standpoint, the best place to have it is in a holster on your person. You don't want to end up looking for your gun in your car if you have to defend yourself.
So there's a lot of variables, a lot of complexity. It varies by state, by country. What is a loaded gun? These are a ton of questions that hopefully we've given people a few ideas of questions that they should be asking. And so, and what it comes down to, if you're in a self-defense scenario, is this jury, right? Your fate is going to be in the hands, oftentimes, of a jury that's full of people with political prejudice, depending, where they're from, how they were raised, what their conscience is weighing on them in the moment. You don't really want to be in that scenario, or if you are, you certainly want to be prepared for it. So this has been Mark Knapp, and if you want to learn more about him, I'll have his website, I'll have his Twitter profile, and if you are in the Washington area, probably be interested to reach out to him. And I'll give you the final say, Mr. Knapp. Any final thoughts?
Well, think like a man of action and act like a man of thought. I didn't come up with that quote myself. I think it's from Henry Bergson or something like that. But he's not a conservative, but it's a great slogan. Like, you really need to think these things through ahead of time. You don't want to have to be thinking about it when you're facing an imminent threat. I really think the best way to do that is to take some classes. I've got a standing offer to put on a class for a church or a civic organization. I've never had any churches take me up on it. I would even include a synagogue or a gurdwara. That's the Sikh people, The Sikh people have been fighting wars with a certain other faith-based group, for like 500 years. But even put that offer out there for a mosque, provided there's no evidence of any terrorism going on or anything like that. So nobody's taken me up on it yet, but I used to have a column in a Federal Way newspaper called the Firearms Lawyer, and the articles are still online. In 4 years, I had like 102 articles, and one of the articles was about a Punjabi Sikh guy back in Milwaukee. He protected the Gurdwara with a butter knife. These guys it's part of their religion that they carry a knife. I got a tremendous amount of respect for it's actually pronounced Sikh. Everybody says Sikh, but it's S-I-K-H. I think it's pronounced Sikh. I don't want to sound like I'm being politically incorrect, though. So we'll just call them the Sikh Punjabi. It's part of their religion that they carry a knife, because they've been fighting for 500 years back in Punjab. I think some of them have started carrying weapons, because they get attacked sometimes because people get them confused with another religious group. they wear these turbans on their head, and they're just great people. But anyway, the point being, I still have that offer out there. I'd like, maybe to have my expenses paid if I have to travel. But I wrote a whole book on what the Bible says about armed self-defense. So kind of a work in progress. I've been working on it for about 10 years. But if anybody's interested, my email address is mark@firearmslawyer.net. And you can also get my email off that website, and I'll send the manuscript. It's about 100 pages. I don't know, maybe one of these days I'll make hard copies, but I think it would make a great textbook, like for a church security group, or, maybe like a church or some other religious group or civic organization that's thinking about starting some kind of a armed safety group. And there's a whole chapter in there just on church safety and that kind of thing. Just kind of putting in a plug for my book. Make it available free of charge if somebody just makes the request.
There we go. We'll have the email in the show notes, and maybe he could only represent you if you're in Washington, but that doesn't mean he couldn't speak for you elsewhere in the country, or talk with you in some other way. So definitely reach out to him if you've liked what you've heard. And Mr. Knapp, thank you again for being on the show.
Yeah, thank you.
Hey, thanks for listening. Look, I could use your help real quick. If you could share this, engage with me in some way, leave a review anywhere. This really helps me to break the technocratic shadow banning that is happening with my brand. And of course, if you really want to escape the technocracy, go to escapethetechnocracy.com. Privacy tutorial series, books, consulting, and of course, you can leave a donation. Thank you very much.